Hello students, in this class we are going to see about Negotiable Instruments Acts, more specifically section 138 of Negotiable Instruments Act. So, what are some of the key aspects of negotiable instruments under section 138? You have to understand that there are some specific timelines that has to be followed for section 138 to be valid. So, first is the check must be presented within 6 months, that is actually as per RBI now it is 3 months. So, the check must be presented within 3 months of within the check's validity period, and you must send a demand notice, that is written demand notice, within 30 days. So, once the check gets bounced, that is when you are presented within its validity period, that is usually within 3 months. Then after the check got bounced, within 30 days you have to give a written demand notice. Then after within 30 days, once you have given a written demand notice, the drawer must pay the money within 15 days, and if they fail to pay within 15 days, then you can bring an action under section 138. So, let us get into some of the nitty-gritties so that you can understand and answer whatever questions that has been put to you. First, the most important thing is the check must be dishonored only for insufficiency of funds and whether you have exceeded the overdraft limit. That is, the check must have bounced due to the reasons attributed to the drawer, that is the drawer has not maintained sufficient funds or he has exceeded the overdrafting limit. If the check is bouncing due to things which is beyond the control of drawer, like any issues by any internet or any kind of technical issues on the bank side, then you cannot file a case under section 138. Next, what is the punishment? The punishment is up to 2 years, imprisonment up to 2 years, and fine twice the check amount, and both imprisonment and fine may be imposed as punishment. So, like I said, the essential conditions is, first initially you have to present the check within its validity period, then that is usually 3 months, and then a written demand notice has to be given within 30 days of dishonor, and if within 15 days of receiving the notice, if the drawer fails to make any payment, then a case can be filed. That is the most important aspect. Important things that you must know to answer questions, that is explanation of debt or liability, that is the check must have been issued for a legally enforceable debt or liability, that is it must have been issued for a legally enforceable debt or liability. So, if you are giving the check as a gift, donation or charity, then section 138 will not be applicable. What are some of the important timelines to remember? Like I said, the check must be presented within 6 months, that is actually 3 months. Then notice must be sent within 30 days of dishonor, and payment after receiving notice, there is a 15-day time period within which the drawer must pay the amount. If he fails to pay, then you can bring action under section 138. Now, section 139 talks presumption in favor of the holder. What is presumption in favor of the holder? It means that, like I said, there are certain prerequisites for bringing case under 138, that the check must have been given for legally enforceable debt, and next it is for a discharge of debt, and it is for legally enforceable debt. So, this is once if a check is given by a drawer, then it is presumed that he is giving it to discharge a debt and for other legally enforceable liability. Now, the burden is on the drawer to prove that he has given the check as a gift or charity, and it is not specifically for discharging debt. So, that the burden of proof is on the drawer, and he has to prove on the basis of preponderance of probability. Next, no defense on lack of knowledge. Now, the drawer cannot say that he had no idea that there were less funds. So, this defense cannot be taken. Say, for instance, if a person is giving you a check and the check is returned, say, on the basis of funds being insufficient, now the drawer cannot say that he was unaware of this fact. So, no defense on the lack of knowledge. So, this defense is not allowed. Now, another important section in NI Act with regard to check bounce is section 141. So, this is similar to 138. 138 is for individuals and 141 for companies. So, the key point here is the company itself is liable, and you must understand this very important, that is, every person in charge of the company's business at the time of offence is also guilty. So, every person in charge of company's business at the time of an offence is also guilty. That is the key point that you must remember. So, whenever a bank or anybody as a law officer or as a manager of a bank, you want to file a case, you must remember that every person in charge of the company. So, it is not necessarily like he should be a director or a managing director. Every person in charge of the company can be booked. There are certain exceptions, we will see the exceptions, do not worry about that. So, what are the provisions? So, like I said, every person who at the time of the offence was in charge of or was responsible to the company or for the conduct of the business of the company shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. So, that is the most important aspect, that is, every person who at the time of the commence of offence was in charge, was responsible. And there is one proviso that says that, say this guy might be unaware of this check being issued for that. So, if he can prove that the offence was committed without his knowledge and that he has exercised all due diligence to prevent the commission of such offence, then he might be given a waiver. But the major crux of this is that every person who is in charge of or was responsible to the company can be booked. So, that is the most important thing. Every person who is in charge of and who is responsible for the company can be brought under the purview of this section. Now, there is an exemption for government nominated directors, that if the person is holding a position of directorship in the company by virtue of employment on central government or state government or financial corporation owned or controlled by central or state government. So, if it is a financial corporation owned by the government, or if he is appointed by the government to be as a director to the particular company, then he can be exempted. So, first thing you have to remember is every person responsible for conduct of the business of the company can be brought under. And the next thing is government appointed directors are exempted. So, the person who has committed the offence in connivance, consent or neglect, even they can be brought under the purview of this act. So, if it is a partnership, then usually instead of director it will be a partner in the firm, and company means a body corporate, includes firm and association of individuals. This is just a basic definition that you have to know. So, who can take cognizance, where the case can be filed? Section 138, it should be filed in no court inferior to that of a metropolitan magistrate or judicial magistrate of first class. So, the jurisdiction. So, where would you file the case? It is usually the bank where or it is usually the payee. If you want to go by the words of the statute, then it is the payee uh, where where the payee maintains the account. For instance, if you are given a check to be cleared, and if SBI, if you are presenting the check in an SBI's office in Chennai and they say there is funds insufficient, then the jurisdiction would be in Chennai. Similarly, if you are given to something to HDFC Bank in Tanjavur, then it will be HDFC Bank, then it will be Tanjavur. So, the jurisdiction for inquiry and trial is if the check is delivered for collection through an account, the branch of the bank where payee or holder in due course is situated. Now, you know who is holder in due course? Holder in due course who is holding the check in good faith that this is a properly acquired instrument. And similarly, if the check is presented for payment by payee or holder in due course, otherwise through an account, the branch of the drawee bank. So, it is simply put which branch the check is being presented and the check is being returned as funds sufficient. That is the place for jurisdiction. Now, of course, section 138 cases can be tried summarily. So, usually it should be tried summarily, and in some exceptions, like if the magistrate deems that the sentence exceeds 1 year, or if it has otherwise desirable to try the case summarily, then they can. So, if like you said, in summary trial there are some limited powers for the magistrate. He cannot give imprisonment exceeding 1 year or fine exceeding 5,000. Note, the punishment for a check bounce is 2 years of imprisonment and double the amount of fine as check. So, in case if the check is for 1 crore or something like that, then usually it won't be tried summarily. It will be going through the normal trial process of the BNSS or the CRPC, whichever is based on the date. So, the cases should be tried by the judicial magistrate of first class or metropolitan magistrate. Be thorough with that. It should be tried by the judicial magistrate of first class or metropolitan magistrate, and as far as practicable, it should be a summary trial. And in case if it is if the magistrate deems that the sentencing may be exceeding 1 year, then a normal trial procedure can be done, and it should be done as fast as possible. Unnecessary delay should not be taken, and the trial must come to an end within 6 months. Now, this is another important section that was recently introduced by recent amendment, that is power to direct interim compensation. So, when you are trying a case and if the drawer pleads not guilty, if he is pleading not guilty, then the court can award an intervention compensation for 20% of the check amount. So, it cannot exceed 20% of check amount. So, the discretion with the court can award an interim compensation, and the interim compensation should be paid within 60 days, and in case of some proper delay or sufficient so cause, then 30 days can be given an extension. So, this is what is about interim compensation, but provided if finally if the drawer is acquitted, then the complainant must repay the interim compensation with the interest at RBI bank rate. So, they have to repay with the interest at RBI bank rate. So, the recovery of interim compensation, that is based on 421 of CRPC, or now whatever section that is relevant as per BNS. So, again, the final amount or final compensation awarded by the court can be adjusted against any interim compensation that is paid. Section 144, that is service of summons. So, it talks about how the summons can be served. It is by magistrate may direct the summons to be served by the accused or witness residence, business place or workplace, by speed post or approved courier services. So, these are the ways in which the summons can be served, and an acknowledgement signed by the accused, an endorsement from postal or courier that it is served, and those are the normal ways in which the summons can be. Then an evidence and affidavit has to be given. This is another important thing, and complaints evidence may be given an affidavit in inquiry, trial or proceeding, and court may summon and examine any person giving evidence and affidavit. the court shall summon if requested by prosecution or accused. So these are all basic things that you must know. There's nothing then bank slip is prima facie evidence. So the slip of the bank which says that a check returned due to funds being insufficient is a prima facie evidence. So that is there. And another important thing is that it is a compoundable offences. Offences are compoundable. So this allows settlement between the parties. That means the parties can settle out of the court. So it is a compoundable. And finally, what we are going to see about power of the appellate court to order payment of pending appeal. So in case the trial court has completed its inquiry or completed its trial and it has given a final order, then the accused has right to appeal. So before appealing, the appellate can order payment, that is like deposit 20% of the fine or compensation. So this is very important, at least 20% of fine or compensation. So this amount is in addition to any interim compensation paid under section 143A. So 20% of the fine amount of which is ordered by the trial court or compensation can be awarded as an interim compensation, and it is in addition to any interim compensation paid under 143A. So the timeline again 60 and 30 days. So the appellate court may direct the release of the amount to complainant any time during the appeal. So it's similar to that. If the accused is finally acquitted or the appeal succeeds, then the compensation has to be returned based on the RBI bank rate. So the major difference between section 148 is that this will apply to all cases, even if the cases have started before this. This is actually based on an amendment, recent amendment. So even before this amendment came into picture, the court has the case has commenced. Then also this section will be applicable, whereas section 143 is not like that, because that is an interim compensation with a discretion, and that would only apply to cases which came into being after the particular amendment was made. Now remember, this is something most usually students confuse, that is 20% of what? It is the 20% of fine or compensation amount. So you must be able to know this well. And if you compare it with these 143, that is interim compensation in 143, then that is 20% of the check amount. So that is the major thing that you must remember, that is in case of while appealing, it is 20% of the fine amount or compensation, whereas in 143A, but during the trial period, interim compensation cannot exceed 20% of the check amount. With this, we conclude today's topic. Hope you had time, and if you like this, just press the like button and then share it with any of your friends or anybody who feel this video will be helpful, and subscribe to my channel. Thank you.